Thank you, Mr. President. Good morning. Bienvenidos a Puerto Rico. Muy buenos días. I am honored to have been invited to address the American College of Trial Lawyers and to be among such distinguished members from the bars of the United States, Canada, and Puerto Rico. I am especially pleased to welcome to Puerto Rico an organization that is dedicated to the fundamental principles of judicial independence and meaningful access to justice for every citizen. As a member of the Board of Directors of the Conference of Chief Justices, I can assure you that the judicial systems in our countries and states share these same concerns. This audience knows very well that our citizens depend on strong courts to uphold the Constitution and to rule on cases fairly and impartially, based solely on the facts and the law. It is fair to say that strong courts are an essential part of our democratic system, for they provide vital balance in our government through the system of check and balances. For this reason, the judicial branch in every state and country must be independent of outside influence, be it popular, prejudice, or political interference. A fair and impartial legal system is crucial to maintaining the rule of law and upholding the laws that govern societal relations in an expedient and an efficient manner. Nonetheless, we should never take a strong and independent judiciary for granted. Chief Justice Margaret Marshall, just recently, Chief Justice of the Supreme Court of Massachusetts, Supreme Judicial Council of Massachusetts, in an address before the ABA last week, recently noted that a perfect storm of circumstances threatens much that we know or think we know about our American system of justice. We are all aware of the recent developments related to the global financial crisis. Most states and countries are facing shortfalls in their budgets for this year, and severe fiscal problems are very likely to continue into the following year as well. Courts in most states and countries have not been exempt from this troubling reality. Trial lawyers and litigators know that their clients and cases will bear the direct consequences of the current fiscal crisis if courts do not remain strong, impartial, and independent. You know better than anyone else that an expeditious and efficient legal system depends on the strength of the judiciary and the administration of justice. 3 years ago, the Board of Regents of this organization approved a policy paper titled Judicial Independence, a Cornerstone of Democracy which must be defended. This publication eloquently expressed that judicial independence is not established for the benefit of judges, but rather for all of us. It is the citizens who are the intended beneficiaries of fair and impartial administration of justice consistent with the rule of law. The fact is that this goal can only be met if there is a high level of respect and deference on the part of the other branches of government and the public for the expertise, the impartiality, the accountability, and the commitment to positive reform demonstrated by the judiciaries across the globe. Consequently, we do not hesitate to recognize that judicial independence is strictly intertwined with judicial accountability. It is our responsibility to promote confidence in the quality and professionalism of the bench, in the court's productivity and the quality of justice being provided, and in the demonstrated ability to make efficient use of very scarce resources. Such an environment is only possible if courts and lawyers work together in establishing a reputation for excellence in the management of our court business, not just now, but on a continuing basis. To achieve this goal, the Conference of Chief Justices and the American Bar Association have called for more and better resources to be directed to the administration of justice of state courts. Accordingly, it is also the policy of the American College of Trial Lawyers to address in an appropriate manner threats to judicial independence wherever they manifest themselves. In this regards, the extreme revenue shortfalls currently facing the public sector pose an additional challenge in the path to an independent legal system. All public entities, including the judicial branch, must make painful and difficult choices to bear their fair share of the fiscal crisis affecting governments everywhere. However, some court systems are being asked to take on a heavier burden, effectively threatening the stability and independence of the judiciary. In the past few months, the judicial branch of New Hampshire announced that it would halt all civil and criminal jury trials for a month to save on per diem payments to jurors. Budget cuts in Florida have left 280 court personnel without jobs. In Minnesota, 3 judicial districts have been shut down for half a day each week. A courthouse has been permanently closed, and various civil arbitration services have been terminated. Last week, judges in Spain went on strike demanding better working conditions and new technologies for their courtrooms. These are just a few examples of how the economic downturn has reached the courts in the United States and abroad. In most of these cases, such drastic measures were a direct result of inadequate funding. They are not examples of judicial accountability, but of a looming crisis that can fundamentally alter the constitutional system of checks and balances as we know it. Judge Lernhan once warned us that if we are to keep our democracy, there must be one commandment: thou shalt not ration justice. Today, these words of wisdom are more relevant than ever, as states and countries all over the world, including Puerto Rico, deal with an economic crisis of unprecedented proportions. It is worrisome that some courts in our countries are reaching the point of being almost unable to function at even minimally adequate levels. This is particularly more troubling during the times of economic distress, when people turn in even greater numbers to their courts for relief and for protection. Jonathan Lippman, who was this week sworn in as Chief Judge of the Court of Appeals of the State of New York, as Chief Judge of the State of New York, recently compared state courts to the emergency rooms for society's worst ailments: substance abuse, family violence, mental illness, mortgage foreclosures, and so many more.